6 p.m. having arrived, I'll call to order this regular meeting of the Finance, Organization, and Personnel Committee. This meeting is being broadcast live on the City of Keene YouTube channel and channel 1302. The video is also streamed on the city's website and is posted on the website by the end of the next business day, barring any technical difficulties. Copies of printed agendas are available in the wall pockets just as you enter the meeting room. The public and other city councilors will be recognized to ask questions and make comments on agenda items under discussion. After being recognized, all remarks are to be made through the chair. I will not recognize an individual a second time until everyone who wishes has had an opportunity to speak. Anyone who wishes to address the committee is asked to go to one of the microphones in the room and identify themselves by name and address prior to speaking. Written comments from the public will be accepted at the city clerk's office until Tuesday at 2 p.m. The minute taker participates remotely. The committee members, be sure to turn on your microphones when speaking. If the minute taker is unable to hear, they will ask that you speak louder or turn on a microphone, or there'll be a white light flashing in front of us to remind us. With that, we have everyone present, so we'll start our agenda with the first item is Jared Goodell, place of assembly permits.
Good evening. Jared Goodell, 39 Central Square, 201 Keene. And this is my attorney, Joe Hoppick. I don't know if you need to recognize.
Attorney Joe Hoppick of Keene, Church Street.
First, I just want to thank Councilor Remy for making sure that this matter got referred back, and for the full council for sending it back at last week's council meeting. As you may know, that there was a little mix-up, I guess, with emails at the city clerk's office, and I wasn't notified at the last meeting, and that's the reason for my absence. I did, however, have the opportunity to watch the recording of the meeting and listen to arguments made by the fire chief and Attorney Mullins. I will address their comments from that meeting tonight and ask that this committee reconsider your action in accepting my petition as informational. As a brief refresher on the background of this matter, back in July of this year, I opened a business on Emerald Street, which has an occupancy of more than 99 persons and is therefore required to obtain an assembly permit from the fire department. They did issue that permit to me after they conducted the required inspection of the business. In New Hampshire, assembly permits are authorized by state law, specifically RSA 155:17 through 39. Shortly after the permit was issued, I received a bill from the Keene Fire Department for $70. The line item of the charge was for an assembly permit. Knowing that the charging for an assembly permit fee was specifically against New Hampshire law, I questioned the fire chief about the charge. He immediately responded that that was for the inspection and not the permit, despite the language used on the invoice. I then petitioned the Keene City Council regarding this issue. So as I see it, there's both state law and city code at issue here. The relevant statute, RSA 155:19, which I provided to this committee and in my original petition, and I believe at the last meeting I provided you a informational bulletin from the Department of Safety. That statute specifically says that assembly permits shall be issued without charge. On the contrary, Keene City Code prescribes a fee for assembly permits under the heading permits, life safety permits, and the line in the code in Appendix B is place of assembly permits, valid for 1 year, $70. And that's what my business was charged for. Now, Attorney Mullins made several arguments to you at the last meeting. He did concede, I believe, after watching the video, that the city cannot charge for an assembly permit, but that he believes that the city can charge for the inspection required to obtain the assembly permit. If we assume for a minute that Attorney Mullins is correct that a charge can be assessed for the inspection, and I don't believe that he is, that is not what the current text of city code reads. Attorney Mullins seemed to suggest that Keene intends to charge for the inspection, but the city code as written, and I quote Attorney Mullins from the last meeting, isn't clear. But it is clear, from my perspective, that the city of Keene charges for the permit. That's why the invoice that I received says assembly permit, not assembly permit inspection. At this time, city code only authorizes a fee for assembly permits, not for assembly permit inspections. In fact, there exists a subheading for life safety inspection fees in Appendix B, and there is no assembly permit inspection fee listed. City staff cannot add or modify language to city code on a whim to meet their revenue desires. My first ask of this committee tonight is to declare the fee I was charged for an assembly permit be reduced to zero. As it pertains to changing the fee in question to an inspection fee, which I believe is the intent of city staff, is to present you with a revised code which would change the assembly permit fee to an inspection fee. And I'm not sure that I really need to address that here, but Attorney Mullins stated that you can't simply take one line of the law and apply it without looking at the broader text of the body of law that the text in question belongs to. And I agree with Attorney Mullins, but he failed to educate you as to the entire body of law pertaining to assembly permits and the reason why even charging for an inspection for an assembly permit would be against the law in this state. In order to obtain an assembly permit, as I mentioned earlier, the fire department it's required to perform an inspection. This is prescribed by 155:34, RSA 155:34. I emphasize that the inspection is a requirement to obtain the permit. This requirement is contained in the same body of law that prohibits a charge for the permit. Now, it's clear that the legislature did know what it was doing when it authored the body of law pertaining to assembly permits. It clearly intended that in order to obtain an assembly permit, you must first get an inspection by the licensing authority, and that the assembly permit would be issued at no charge. So you can't, it's tough to fathom that the legislature would require an inspection for the assembly permit, but then say the assembly permit is at no charge, all within the same body of law. It's also worth noting, as I'm sure you know, that New Hampshire is not a home rule state. That means that cities and towns only have the powers the legislature has expressly given them. All municipal authority must find its basis in some state law. When a municipal ordinance conflicts with the state law wins. That is, the local ordinance is preempted and therefore unenforceable. Therefore, the state law barring a charge for an assembly permit not only preempts Keene's code for charging an assembly permit, but it also fails to give the city any authority to charge for an inspection for an assembly permit. Now, I understand that my initial petition to the council asking that a refund be given to all persons who previously paid for an assembly permit in the last 2 years gave many of you heartburn. And I want to take that off the table tonight. And this is the specific relief that I'm asking for. Again, that the committee recommend that the fee charged to my business, Podunk Productions LLC, for an assembly permit be reduced to $0 and that no further charges be assessed for the assembly permit. I don't want to receive a new bill that says inspection fees after tonight because, quite frankly, there's nothing in city code that authorizes that. Second, I'd ask that the committee recommend that the city council remove the fee for assembly permits from city code as soon as possible. And then if the city staff wants to bring back a new code which would charge for inspection fee for assembly permits, I think they can do so at that time, and that inspection fee can move through the process of public hearings, and I would plan to ask that the Department of Safety weigh in on the legality of such an ordinance at that time. Now, that's the relief that I asked for. I certainly am open to any questions that you might have for myself or Attorney Hoppick or any debate that we have on the interpretation of the law.
Mr. Hoppick?
Yes, if I may give you some paper. I've made 5 copies for each member. I didn't think of giving Tom one, so. Just look at one before you do it. All right, you can intercept me. But I have 4 left you guys here. What I want to do is go over a few things with you, is just to highlight what Mr. Goodell told you. So the first page, pardon me, is the page that Mr. Goodell referred to. Life safety permit fees. Place of assembly permits valid for 1 year, $70. There are other places in the code, as Mr. Goodell mentioned, where it calls for inspection fees. And he's correct. There are no places in the code that would refer to inspections related to a place of assembly permit application. So the next page is the beginning of chapter 155. And if you turn 2 or 3 pages in, you'll see RSA 155:19. It's on the 3rd page of the chapter. A permit shall be obtained from the licensing agency, that's the fire chief, by the owner or operator of any place of assembly. Jared operates a place of assembly. He needs an assembly permit. Such permit shall be issued without charge for 1 year from the date of issue and shall be revocable for cause. I note that the statute says 1 year. Your fee for $70 says it's valid for 1 year. That's not a coincidence. Application for permit shall be made to the licensing agency who may require building plans showing types of construction, exits, aisles, and seating arrangements and details of decorations. No permit shall be issued by the licensing agency until the provisions of this chapter have been complied with. Now, if you flip the page, remember, you read this chapter as a whole. You don't pick and choose your sections. Section 34 says the licensing agency shall inspect or cause to be inspected each place of assembly. Such inspections shall be at least semi-annually. I note that there are no semi-annual inspection fees in your code. And at such times, including time of occupancy and use, as to assure compliance with these regulations, and such orders may be issued in connection with the maintenance of aisle space, the prevention of overcrowding, the use of decorations, the maintenance of exits, collapse of revolving doors, and the maintenance of fire appliances, et cetera, et cetera. So there's a good deal of overlap between Section 34 and Section 19. But I guess the point I want to make here is that an inspection is required for the issuance of a place of assembly permit. And if you go back to Section 19, such permit shall be issued without charge. To issue a permit, you must inspect. That's part of the process. You cannot charge for a permit to be issued, which shall be issued upon the application of a fee and satisfactory inspection. So our view of this is that the fee charged by the city is unlawful when sections 19 and 34 of 155 are read together. And I would concur with Mr. Goodell's request that you essentially, because this ordinance is in place, you waive the fee as to him and change the code so it's consistent with state law. Now, as to refunding a bunch of people from the past, I take no position. But I do want to add one more thing about, because Jared sent me the video link for your last meeting. And Mr. Mullins talked about the case of Cox versus New Hampshire, 312 U.S. 569. Now, this case, Mr. Mullins talked about a distinction between permits and licenses, the words permit, license. That's just not accurate. This case talks about a parade permit and whether it's a violation of free speech and the exercise of free religion. The narrow holding of the case is that a municipality is within its authority to control the use of public ways, and it cannot be denied the authority to give consideration without unfair discrimination to time, place, and manner concerns in relation to the safe and proper use of public streets. So in other words, a municipality has the power and authority to issue permits to people if they want to have a parade or if they want to march. You do this all the time with these folks on Central Square. You have the authority to issue permits so people can exercise their rights to free speech or exercise their religious rights, whatever, in public, on public property controlled by the municipal authority. Now, the restriction really is whether the time, place, and manner are reasonable. And reasonable refers to, making sure you're not interfering with traffic, pedestrian traffic, the flow of goods and services and commerce going through the city. Restricting assembly in regards to protecting those kind of things, perfectly legitimate under the First Amendment. But nothing in the Cox case distinguishes between permits and licenses. And out of curiosity, I went to Merriam's online to see if there's a distinction between the word license and the word permit, and there really isn't. A permit, for example, is a written warrant or license granted by one having authority. So in effect, they're interchangeable. And the distinction between the two words, because you see them, if you look at 155.18, and you see the word license used in there, but I submit to you it's a distinction without a difference. And I don't think you should get bogged down in that. But the point we're trying to make, obviously, is that the fee for a permit under Section 19 is not lawful. And that's all I have. Thank you for your attention.
Thank you. Members of the committee? Questions, discussion? Let's see, did we? Yeah, I'm trying to go through our sort of protocol.
No, thank you to the committee, and I appreciate actually the comments that are being tendered tonight. A lot of them, frankly, I agree with. There is no doubt that the statute, 155:19, does not allow for the charge for a permit. We explained that before. And our city code appears to do just that. So as was pointed out, we will be seeking to amend the city code to clear up that problem. The underlying question is the one that's being presented tonight by Mr. Goodell and Attorney Hoppeck, which is what's the authority with respect to the second piece of this, which is the inspection piece. Now, not surprisingly, I sort of disagree with the analysis that's being tendered to you tonight by the two of them. No surprise, you put two attorneys in a room and they are probably not going to agree. But from my perspective, you know, as we talked about before, and I think as Attorney Hoppeck understands, you do have to read the statutes as a whole. You can't pick and choose from them. I think that it's important that RSA 155-34, I believe the inspection by the licensing agency, A, does give the authority to do the inspection, and B, is silent on the question of whether or not there's any fee that could be charged with respect to that. Now, in terms of that authority, it's important to keep in mind, at least from my perspective, that RSA 155 arises under Title 12 of the state statutes. Title 12 is the public safety and welfare provisions of New Hampshire state law, and included in Title 12 is RSA 153. Well, RSA 153 is basically adopts the fire code for the state of New Hampshire. And 153-6A defines the fire code as NFP 101 and NFP 1. So the fire code in those two sections is adopted into the state through the fire code. And Chapter 155, dealing with places of accommodation, is really an expansion of all of the detail that's contained in NFP 1 with respect to places of public accommodation. Most of the stuff that's in NFP 1 doesn't appear in the statute because it's fairly detail-oriented. But 155 and 153 contemplates NFP 1. And if you look at NFP 1, it talks specifically about places of assembly. And what it does specifically is say that the fire chief, if they call it the authority having jurisdiction, shall be authorized to establish a schedule of fees. Those fees include inspection services. And the NFP 1 contemplates, as does our statute, that there will be an inspection of a place of accommodation, which makes sense. You're not just going to issue the permit without going to the specific location to make a determination as to whether it does or does not comply with the fire code. So from at least my perspective with respect to the city, and with all due respect to the two gentlemen here whose presentations were both very well done, I think that the city does have the authority to charge for the inspection. It does not have the authority to charge for the actual permit that's issued in connection with this. You know, keeping in mind that sort of generally you pick up examples where, you know, a permit is sort of a separate thing from the process that happens before it. That was sort of what was happening in the Cox decision. I don't disagree with Attorney Hoppeck. It came up in a really other interesting context. But the court in that case really was trying to suggest that, you know, a permit is one thing, but the licensing process that you have to go through is the necessary work that has to happen to determine whether or not you're going to operate safely in the public streets in order for us to actually issue you the permit. I don't disagree, actually, on reflection, that the statute, even though it's unfortunately drafted 155, the license and permit, even though the legislature shouldn't have done it this way, is probably interchangeable. But the underlying question that's being presented isn't the one that we're disputing, which is, no, we don't have the authority to issue, to charge for a permit. The underlying question is, as Mr. Goodell raised initially, is does the city have any authority to change the code to actually charge for the inspection process associated with issuing that permit? My perspective on it, based upon all of this, and quite frankly, as Joe would agree, these are questions of law. I don't think there's really much dispute about any of the facts, but I think that the city does have the authority. We did review this with the Office of the State Fire Marshal, going through this, and they agree with that interpretation, at least at this point. So that's the position that we're taking. We will be submitting, I think, into council next week, because I am cognizant of Mr. Goodell's request, which is we should not have an ordinance in place that is, you know, in violation of state law, essentially on its face. But we will be amending it to make that distinction very clear. And that's what I have to offer.
City manager?
I like the idea of fixing it, to be more clear. Thank you, Mr. Chair, for recognizing me. I forgot to say that. The question I have for the city attorney is on the second request of not charging the petitioner. Are there concerns on voiding a fee in this way? Do we have the authority to void a fee like this? I've never had this kind of a request come before us.
Well, from my perspective, and that really is a city council decision, whether or not to do that. But I would offer two things, or actually three things, in connection with that question. The first one is that it's very difficult to look at our ordinance and look at 155-19 and not go, that doesn't look right, right? Very difficult to do that, from my perspective as counsel for the city. So I think that factors into it. The second is, even though this question has never arisen before, the city council has, in various situations, determined, that they could waive or not collect on something. There is no specific authority here to do that, but I would argue in favor, if you were wishing to do that, to waive the fee in this particular context, would be, there is a term in the law called ultra vires, which essentially means without authority. So even though our code doesn't specifically give you that authority, that doctrine, I think, does in that context. And the other thing I would suggest to you, quite frankly, is, I have to say, I've been doing this for quite a number of years now, and there are problems in our code. And from my perspective, I actually appreciate Mr. Goodell coming forward with this, because we do need to fix it. And I think that, frankly, good for him at this point.
Thank you, and, okay, thank you, that was all. Yeah. Thank you.
Just a quick question for the city attorney or the city manager, and I don't know if either of you have this information, but is there any precedent for what other cities in New Hampshire charging inspection fees for
Yes.
these kinds of permits?
We actually went out and did a review of other municipalities, and we have determined that there are some municipalities that are very clear about the distinction between these two things, and there are some municipalities that look like the cities, Keens, with respect to that it's not clear, and some municipalities don't say anything at all about the inspections, but do say that they don't charge for the fee, for the permit. So it's clear that this is an issue that exists around the state at this point. And this was actually part of the conversation that we had specifically with the State Fire Marshal's office in connection with this.
Anybody in the public wish to speak? Yes,
Ma-
sir.
Good evening, Toby Towsley, 500 Washington Street. I have no stake in the game. I don't own a place of assembly, but I'd like to point out a couple things. One, this may seem petty over $70, but Jared is passionate about what he does, and I think he's bringing up a valid point. I think it's always nice to be able to clear stuff up like this. But something that, when I was reviewing the minutes of this meeting from before, that was brought up, that Mr. Mullins had thought that the legislator did stuff without knowing what they were doing. I'm not sure how he worded it. And I think that they were probably quite cognitive of what they were doing when they passed this ordinance. And if we were able to go back in time and sit in while on the discussions, I think you'd probably find that they were discussing things like they didn't want to overcharge for inspections and fees to push out smaller businesses and whatever, And so and the way this is worded to me, not being a lawyer, it sure looks like there shouldn't be any fee for this at all. That's my personal feeling, and I think Jared's on it. But I think that the other piece of this that strikes me is that the fire chief was saying that this amounts to $8,400 worth of income, which is an insignificant piece of his budget. And so why not just err on caution and do away with it? I mean, that's what I would say. Thank you.
Thank you. I'll come back.
Oh, okay,
second
no
back
rush.
around. Anybody else in the public? Okay, back to you.
I'm aware of your rule that you want to get everybody on the table before seconds get served out, so thank you very much. Now, I just wanted to reply to Attorney Mullins' comments about the NFP1. I don't know if any of you have ever seen that before, but it's a colossal, detailed minutia of technical rules in terms of fire and life safety codes. And he's correct, 153 does incorporate that, and you can't find that really anywhere in the public domain. You have to buy the book. But that's not the point I want to make. Section 155.19 says the permit shall be issued without charge. As I said before, to issue the permit, you have to do the inspection. So inspection is part of issuing. By virtue of that connection, you cannot lawfully charge anything for the inspection in the context of this place of assembly permit. Now, we've given you that, again, you read the chapter as a whole, not individual words and phrases. We've given you the language in black and white. Mr. Mullins talks about the NFP 1, but I don't see anything in black and white that I can look at to say, oh, he's right. And I challenge him to find some code language in that book that speaks to what fees you can and cannot charge. You have that in your code separate. And I just think that Mr. Towsley and Mr. Goodell are both correct in that you don't have the authority to charge an inspection fee or an application fee or any kind of fee associated with a place of assembly license. That's our view.
I just want to add to that, because I think we're all sort of getting off into the weeds here and sort of putting the cart before the horse when it comes to the inspection fee. I think we can all agree that there is no inspection fee right now that is in the code. There's nothing before you, new code that would rewrite that. I think the very narrow question that you have tonight is the current code legal, right, on its face? And I think, I could be wrong, but I think Attorney Mullins agrees that it is not. And therefore, I would argue that the only action that you could take tonight is to recommend that the fee that I was charged be reduced to $0, and that unless and until city staff or someone brings up new code to charge for an inspection fee, I think that probably is the more appropriate time for a debate about whether or not inspection fees can be charged for an assembly permit. So I just want to make sure that the focus is narrow here, that the question is the current code legal? I think we all agree it's no, and I think that the fee should be reduced to $0. And unless and until there's a new code proposed, I don't think we need to debate the legality of the inspection.
Thank you.
Mr. Chairman, I was going to essentially say exactly the same thing. That really, the question now is just as was presented. We do have a difference of opinion with respect to the authority of the city to do a charge for the inspection, but that's for a later point. To the extent that we put in an ordinance that makes that sort of distinction, that is the time to have that conversation.
Thank you. Yes, sir.
I guess the question is there a recommended motion that would, for us to recommend correcting this and the correct way to potentially waive or reduce or non-collect the $70?
Yes. And my suggestion is frankly that you do them in two separate pieces. Because essentially they are kind of two separate things, and there may be differences of opinion up at the council level. But I think the first motion would be to request that the city attorney's office draft an appropriate amendment to the fee structure with respect to places of assembly to make the distinction between costs for the permit and any cost for inspection. We'd have to hammer out that language. That would be the first suggested motion.
So moved.
All right, is there a second to that?
Second?
All right, it's been moved and seconded. Yes, ma'am.
Well, I just want to say that I appreciate that Jared Goodell brought this forward, because we, as a community, are going to benefit from it. We're going to improve our existing code, and it's something going forward that won't be confusing. So thank you for all of your effort in this. And I certainly support this motion as well as waiving the fee.
Thank you.
Any further discussion? Certainly not, we're not going to be the only community that's going to benefit from this. I think everybody's going to look at it, so if no further discussion, there's been a motion and a second. All those in favor? No one's opposed, all right.
And then my second suggested motion would be, it actually would require a refund, not a waiver because it's been paid.
Just to be clear, I have not, sorry to interrupt, I have not paid it.
Thank you. Did not realize that. Thank you, Mr. Goodell. I appreciate that. So the motion would be to waive the fee that would have been charged to Mr. Goodell for the assembly permit.
So moved.
Second?
Further discussion up here? Okay, so all in favor? No one's opposed, unanimous. Thank
Thank
you.
you.
We'll get to work on it.
Thank you.
The second item is acceptance of cybersecurity grant.
Thank you, Mr. Chairman, fellow committee members. Aaron Costa, Assistant Public Works Director, Operations Manager of the Treatment Facilities, here tonight to ask that the city be able to accept a cybersecurity grant from the New Hampshire Department of Environmental Services in the amount of $62,300 for a cybersecurity implementation project. Water and wastewater utilities, as well as other folks, but, can be the subject of various types of cybersecurity attacks. And these attacks can affect the system's operations and the utilities' ability to perform essential tasks. The city will use these American Rescue Plan Act cybersecurity grant funds to implement the cybersecurity improvements. The water and sewer utilities worked with the city's IT department as well as an outside consultant to perform an assessment. And the findings of that assessment are the basis for this grant work. And the end product is that the city's utility systems and network will be better protected and more resilient against possible cyber attacks.
Thank you. Questions? Public? No questions. Motion, we'll start
You got it.
down here.
Move to recommend that the city manager be authorized to do all things necessary to accept, execute, and expend a cybersecurity grant from the New Hampshire Department of Environmental Services in the amount of $62,300 for a cybersecurity implementation project.
And I second.
Been moved and seconded. Any further discussion? Members of the committee? Seeing none, all in favor? No one's opposed, unanimous.
Thank you very
Thanks.
much.
Thanks, Aaron. City assessor, there he is.
Good evening, Dan Landell, City Assessor. I'm here tonight to talk about a property that the city owns off of George Street. This tab, this map.
City Assessor? Your mic. Thank you.
All right. So again, Dan Landell, City Assessor. I'm here tonight to talk about a city-owned parcel off of George Street, known as map 532, lot 044. This is about a half an acre lot, has 33 feet of frontage off of George Street. Because of its shape and size, it's not really a buildable lot at this time, as you can see with the map that's been included in your packet. The city took this in 1977 by tax deed. During those times, the city council talked about this parcel and concluded that there was no need to hold on to it. There were prior attempts to see if there was interested in the butters purchasing it. Nothing ever came to fruition, and so the city still owns it. Up until recently, when the butter approached the city, looking to see if the city would sell it to them. At that point, we decided to send out a proposal to see if there was anyone interested in it. We also sent certified letters to every single one of the butters just to make sure it was a fair process, that everyone knew that this parcel, that the city was looking to dispose of it. We only got one bid back. So the reason why we're here tonight is it was never clear that the city council specifically gave authority to the city manager to negotiate and execute the sale. So that's what we're looking for tonight. Obviously, the sale of this property would remove any liability from the city, places the parcel back on the tax rolls, not a significant parcel by any means, but it does provide some further development potential possibly for the abutter if they purchase this. Without taking any questions.
Thank you. Questions? Yes, sir.
Given the odd shape of the parcel, was there an original intent of putting a road here or frontage here?
So we've looked at, there was a plan at one point, there was a proposed street, the city never took it, and court would probably have the better words for this, but never was an official layout for the property. They never accepted it as a road. But I think that was the proposal by whoever came up with the plan.
And there's not physically a road or driveway or anything on it right now?
No.
Okay.
It's-
Thank you.
Other questions? Members of the public? All right, motion, please.
Move to recommend the city manager be authorized to do all things necessary to negotiate and execute the sale of 0 off George Street, map 532, lot 044.
Second.
It's been moved and seconded. Any further discussion, members of the committee? Seeing none, all in favor? No one's opposed, unanimous. Thanks, Dan. The city clerk, getting ready for another election.
Good evening. So I'm here to talk about. Good evening. I'm here to talk about a recent change in state law dealing with your non-public minutes. This particular piece of legislation was adopted and became effective on October 13th, 2023, so just about a month or so ago. And what it requires is that public bodies have a proactive effort to release non-public minutes when the circumstances that warranted them being kept from the public are no longer valid. So the legislation says that a public body can either develop a process and sort of a timeline and sort of develop sort of the scheme of how this is going to work, or the default is 10 years from the date that you've sealed a set of non-public minutes, they do become public. So I'm recommending that we adopt a policy, and it will do two things. There's an obligation that we look back in our non-public minutes to the year 2013. So any non-public minutes before 2013 are not addressed in the legislation. They're not addressed in what we are proposing as a policy. So we're talking about a backlog of non-public minutes from 2013 to 2023. So that's going to need a process to deal with those in a way that is not an undue burden to the staff in terms of the administration of it, because sort of just that administration would have us giving the city attorney access to those non-public minutes. He would need to sort of review them and consider whether the conditions that warranted the non-public in the first instance were still in effect. In addition to that, at a council meeting, the counselors would need to be provided the full text of all those non-public minutes. And the attorney would give you his commentary as to whether the circumstances changed. And then as you come out of your non-public and go into a public session, you would need to vote on each one of those sets of minutes. So there's going to be a burden for certainly my office to sort of keep this thing organized and watch that timeline, for the attorney to sort of review all these minutes, for your time during a council meeting to review these minutes and then make those public decisions. So as we're thinking about, well, okay, this is our obligation, we understand that, but let's balance sort of the how we're going to do this. Communities are doing it quite differently across the state, and we're sort of all just grappling with it. But it seems to be, as they decide what to do, it's more about how many sets of non-public minutes do they really have. Some communities don't go into non-public that often. We do, I wouldn't say it's often, but the backlog is 100 sets of minutes. So what we're thinking for the backlog is to follow sort of the premise under the statute that says 10 years from the date that you created the minutes, you need to release them. So our proposal is that in 2023, before the end of this year, we're going to review and release the 2013 minutes. And in December of 2024, we're going to review and release the 2014 minutes. And we're going to keep this sort of time frame of December of a year, we're going back 10 years and we're releasing. Now, for the minutes that are more current, today's minutes, last week's minutes, we're recommending that in the month of January and July. July. So we're going to look back in January. We're suggesting that you look back at those minutes from January 2023 to June of 23, so half the year. And in July, we would look back at the minutes for July of 2023 to December. So 6 months back, so that circumstances hopefully have changed. Whereas you want to have some amount of time between when you adopt and when you review. So we're recommending that twice a year, we sort of do this, look back 6 months, and then the backlog, until we wipe out this backlog in December, we look back 10 years. So when the council makes this decision, if you agree with this policy, and you come out of your non-public and you have these motions that we're going to release the minutes of this date and this date, we would accommodate that by having now a template change on your council agenda. So it would always be right before your adjournment for non-public, there would be a potential release of public minutes and non-public minutes, something to that effect. So it's a template on your agenda. We would trigger it, my office would trigger it when it needs to be December or January or July. And we would, after those vote, we would go to, these non-public minutes are sealed. They're separate from public minutes. They have their own binder, their own sort of index. We would take those sets of minutes out and we would make a statement publicly released by the city council on such and such a date. We'd physically take that set of minutes, create a copy, and then insert them chronologically by the date of the meeting into the public set of minutes. And so this would be an obligation of government from this point forward. Backlog will take us quite a few years. We're suggesting we stagger, but then we go through a program that we release twice a year, minutes that are 6 months back. So the city attorney can backfill if I missed any information, but that's sort of what we're suggesting.
Discussion's up here. Yes, sir.
Thank you, Mr. Chair. Two questions. One, what are your thoughts on, I guess, putting in an estimated date to be reviewed as we're sealing minutes as part of that process, saying it's a personnel record, we want this sealed forever, right? It's something very specific. We should just say, this is related to an employee. This may never need to be released, or I don't know what that process works, or at least 10 years or whatever it might be. I don't know what the rules are. Or this is one about a land matter that's very current and we can probably review this one in 6 months and put a recommended review on it so we don't have to always talk about everyone. And then the second part of that is I don't have an appreciation for how long these minutes are for each one. Because I know non-public, I just don't know what it looks like. When you first started describing it, I was thinking, well, we could just do 1 or 2 a week and just knock them out, or a meeting and knock them out over, but I just have no appreciation for what that really looks like.
Typically, they only contain comments and information from staff. It would be quite rare that it actually had comments attributed to a counselor. Certainly, if there is a consensus and a sort of a general feeling of concerns, that may be documented at a very high level. Generally, they are in maybe a half a page, at the most perhaps, page and a half, 2 pages for the minutes. But my reaction to forecast a review date, that's an administrative nightmare.
So, non-public to the city attorney, we do the charter members' reviews in non-public. it seems to me like that would be something that should not be, available to the public. I mean, if I was an employee at any place that I worked, I would not want it to be public.
Unfortunately, you don't work for a public entity in the state of New Hampshire at this point. The law changed quite significantly. Well, at least the Supreme Court our Supreme Court changed the law quite significantly a few years ago, 2 years ago at this point. Personnel-related records are not categorically exempt from disclosure to the public. They have to go through what's called the privacy balancing test, which means we have to look at them and we have to make a determination as to, and it's an objective standard, it's not a subjective standard. We have to make a determination as to whether information contained in that record, there's a privacy interest that outweighs the public's interest in the disclosure. Those are going to be tricky ones to do. The other set of minutes, we don't have very many, fortunately, as far as I recall, at least in the time that I've been here. But as you know, one of the exemptions from disclosure are reputational issues. We are going to have to look at those very carefully. So it raises those kinds of concerns at this point. But there's no, as I said, categorical exemption for personnel-related records.
Thank you, Mr. Chair. So you had mentioned going into non-public to discuss whether or not we should release these non-public minutes. Is the reason why we couldn't just integrate that into the non-public session that's already on the agenda?
The purpose for going into non-public would need to be stated, and actually, I think perhaps you could, but I think it's more of a notice to the public that for that particular meeting, you could, in December, January, July, you could expect a public motion for a release. That's the only reason I was thinking of, just sort of giving more awareness to the public of that potential. But I think you're probably right. I think if we crafted the motion to go into non-public, we could add another 2A, D, A, whatever it is, in the motion, and we'd be all set.
So you contemplate doing this by automation? I mean, you're not going to be burdened with printing copies of all those minutes to go around this table.
No.
We're going to do it all.
No, we've spoken to the IT department, and they will assist us in loading on your desktops a file that'll just be there electronically, and after the meeting, we'll wipe it away. And so there won't even ever be printed copies, but it will be just a sort of another setup process for us to load them onto your desktop that evening.
Okay. Further discussion up here? This is a big item. That legislature just creates all this work for people. Whose motion is it? I think it's yours.
That's it.
Yeah. She's not gonna like you. You start.
No, that's not true.
Move to recommend the city clerk implement the statutory release of non-public city council minutes as outlined.
Second.
Been moved and seconded. Further discussion up here? Seeing none, all those in favor? No one's opposed, unanimous. It's all yours.
This will start at your December meeting. Unfortunately, it will be the last meeting of their year, of your term. So we'll try to be gentle on you.
You're gonna bring dinner for us, aren't you?
Thank you.
We should have included pizza. in the
Yeah.
motion.
All right, item number 5, city manager, Keene Police Department, social worker position. And the police chief is coming up.
Yeah, thank you. So this memo is being put forward by both myself and the police chief, and it's in regards to the Keene Police Department social worker position, which I've talked about several times. I had hoped to put in a grant application to fund the first 2 years to establish the position, but unfortunately, the Opioid Abatement Commission is not likely to put out another RGA that we'd be able to qualify for anytime soon. And I feel because of the issues that we're currently dealing with and the demands of our police department, it's essential for us to move this forward sooner versus later. The funds for this position are available in the city's opioid abatement litigation revolving fund. And so to be able to access those funds, we'll need the council to approve a resolution, which will be at your next council meeting. The resolution will be included for just over $50,000, $52,850. That's about a half year of the position. We have available right now in the fund about $115,000. I expect annually for the next, no, this is the best guess, for the next 18, 20 years, about $40,000 to $50,000 coming into that fund. So in the future, it won't fully fund the position, but it will partially offset the costs of bringing that position into the police department. I included statistics in the FOP memo just about what's happening in New Hampshire and in our community in terms of substance use and the overdose of deaths that have been occurring. And really, this position is about follow-up. When we have a call that's related to substance use, having someone that is going to follow up with that person and connect them to treatment or other services that they may need, mental health services and such. And so the hope is twofold. One, we're able to better serve that person, but also hopefully reduce the return visits that the times that we see that individual, and so really reduce the impacts to the police department. In reviewing this position, we did speak with City of Dover and Laconia. It's wildly successful, very similar model. And in fact, they've added multiple social worker, they may call it a different title, but they've added multiple positions over time because there's been such a demand for it. And I anticipate that we will see the same thing happen here. In addition to providing those follow-up services, referrals and to treatment and other services, the social worker position will also provide some training to police officers. We have very well-trained police officers here, but having someone in-house to provide additional training on substance use disorders and sort of the impact to the individual, I think could be really helpful. Nationwide, police departments are looking at ways to provide services without a police officer. We're not taking a police officer out of a call in this program, but we're hopefully providing follow-up, which then will reduce that second call to that person. And so I don't know if the chief has anything additional to add, but that's what we're hoping that you will support. And the other thing I will just add, Patty wouldn't let me put the resolution in the packet. She said I could only do it at the council meeting, but I am going to be asking you to suspend the rules and vote on Thursday evening to adopt the resolution and move the position forward.
That means we don't have to come right after Thanksgiving, right?
Correct.
Like you. Chief?
Obviously, the city manager said it very well, and I think I'll just be quiet unless you have questions.
Yes, ma'am.
Well, I know when we discussed this early on, we talked about what a great idea it was, and we went back and forth between police and the fire department, and we also imagined adding a second one at some point. My question is, this person is going to be very busy, but would he or she be able to assist the fire department as well? I mean, there's sort of some overlap dealing with overdoses and
Yeah, I mean,
suicides.
oftentimes, if the police department is going to an overdose call, the fire department as well, they're the same calls to the same people. There's 99% overlap for the majority of time, or.
Right, I think we go to all the
Almost all,
overdoses that
yeah.
that they go to, where they're also.
Yeah.
aware of that. I imagine like the overdoses are being handled by EMTs, and so, thank you.
Thank you, Mr. Chair, and thanks for bringing this forward, of course. And just to continue on that note, is there a reason to put it in one department rather than the other?
Yeah, there's a couple reasons. So the reports that come out of the police department are confidential, and so having someone who is an employee of the police department having direct access to that system, and I can't remember your system.
It's a records management system called IMC.
That's it, IMC. So there's that, but also it's more than that, because you see the demands on our police officers responding to these calls over and over and over again. And so that personal contact with the social worker, that additional training about, substance use, I think it will be extremely helpful to integrate this person into what the police department does every day. And I think we'll learn, and I think we'll want even more, once this is in place.
So I just wanted to add that early 90s was on our list of goals in the police department. They had an employee to start working with that. Soon thereafter, there was a cut in budgets, and next thing you know, we're here, and we're getting to it. So I think it's excellent, and I might be a little biased, but police department's the best place for it for this city, because there's always open, never closed, always somebody there. So even if it isn't from an active case, somebody's got a need of that nature, they can walk in and dispatcher's gonna be able to hook them up with some information and get it going. So thanks to you for digging around and keep finding money for these kinds of projects. And I'm sure that we'll be looking to put some additional people on. And it will make a difference over time. It's not gonna happen right away, but it'll make difference over time. If there's no further discussion, motion, please.
Yeah, I'd say that sooner than later, because we don't want that person to get burnt out, and I can see them having more work than they can handle. Move to recommend a resolution be introduced that would appropriate funding for the Keene Police Department social worker position.
Second.
Okay, moved and seconded. Any further discussion, members of the committee? Seeing none, all in favor? No one's opposed, unanimous. Thank you, thank you.
All right, thank you.
The purchasing department. So before you start, congratulations to all the members of the finance department for their recent award for some work well done. You continue to do great work, and to be able to go out and compete for that, and I haven't got the right term, so I'll ask somebody to, it's just great. It's a great job, and I know you had part to do with it. A finance reporting award, so top
you.
shelf people.
Thank you. My name is Yves Gakunde, and I'm the Purchasing and Contract Services Manager. In front of you tonight to talk about the ordinance 2023-15 relating to purchasing. The last time the purchasing ordinance was updated was in 2017 to include the federal purchasing guidelines. Those federal guidelines were recently revised, and the proposed revisions to our ordinance in front of you tonight reflect those changes, and of course, additional recommendation that we received from the departments. Also, it is important that I mention that the last time our purchasing thresholds were revised were back in May 2009, so more than 14 years ago. So how did we get to these changes that we are proposing tonight? The Finance Department received multiple inquiries from the departments to increase the thresholds as prices for goods and services have increased, especially in the last 5 years. So we then met with various staff to understand the problems that they were facing. What we found out was that we identified that currently vendors and contractors cannot guarantee fixed pricing for more than a month. So they just want to get done with the business as fast as they can, and because the pricing are not stable. Going out for bids or proposals for small purchases is very labor intensive and is often associated with added costs, of course, and no guarantee for best pricing. The finance department put together the first draft, and we send that draft to the departments for review and inputs. And during that time, we met with many departments, including Public Works and Parks and Rec, to get the comments and to make sure that the concerns were heard. The finance department then revised the first draft to include all the input we received, and the second draft was sent to the city manager and the city attorney for review before it was sent to you for your consideration. Comparing to other municipalities, those with about the same population size as Keene, such as Bedford and Dover, New Hampshire, these towns are also revising the thresholds to kind of meet the current needs. Other towns or cities such as Manchester and Concord, they just finished this process, and they increased the purchasing thresholds to meet the current market requirements. Nashua is going through the same process as well. So our proposed changes are still more stringent than the federal guidelines and the thresholds from the municipalities that I just mentioned. We believe these changes will allow the city manager and central purchasing to assist the city departments in securing goods and services quickly while maintaining industry standards, auditing internal controls, and cost saving to the city. So the proposed changes are in the document you received as follows. So you see bold, in bold, those are new additions, and strike through the old language that we recommend to remove. I'll be happy to walk you through all the changes if you wish, or I can just take questions that you may have. Thank you.
Thank you, Mr. Chair. And this, I'm going to direct this to the city manager if that's okay, because I don't want to create a task that's a mountain and I'm not realizing it's a mountain. I'm curious, under the current rules, how many transactions fall into each of these buckets versus under the future rules, how many transactions fall into each of those buckets. I don't know if that, my accounting software, that's relatively easy. It's click a few buttons, you get a report of all the things in the different buckets. I don't know what that looks like under the current software, so I don't want to assume that's an easy task. So, and I don't need it for today, but if possible to look at it before next meeting. If it's a mountain, just ignore me.
So I don't think we have an easy way to do it, but we can probably give you a sense of it, maybe the last year or so. But
I'm not looking for long
okay.
history, just a feel for
Okay.
how many transactions, like, are we weekly reviewing a $50,000 transaction? Is it 100 times a week? Is it just a scaling of those types of decisions?
Yep.
Sure.
Because
We can put together some numbers for you.
something, I don't want to make a mountain, that's why I'm,
Yep.
yeah. Thank you.
Go ahead, Brian.
Thank you, Mr. Chair. Another question for the city manager, actually, simply because it does pertain directly to that role. So section 213345, contract change orders. There's two pieces here. So the city manager can approve an increase in contract changes up to $25,000. Totally understand the intent there and agree with that intent. Or 20%, whichever is greater, which is double the current percent that we have here. I was hoping that you could elaborate on the need for why we would increase that.
So we actually had a lot of debate around that language. You know, right now it's 10%, and 10% can mean a very different thing depending upon the contract. But there are some protections in place, because I can only approve items that have already been budgeted for. So you have already approved a budget, it's gone through a capital plan, and I'm working within those numbers. And so this would allow some additional flexibility, because we do quite often come in for contract change orders.
If I may, I can jump in as well. So currently, the city manager is authorized to execute a contract within 25,000. So let's say a contract that we signed for 10,000. For 20%, it will be 2,000. If we say just if we have a change order for 5,000, it's more than 20%. It means we will have to come to council for approval, while she can always sign a contract for 25,000. So that's why we put in 20% or 25,000, whichever is agreed. Whichever is good.
If I may, Mr. Chair, thank you. So I think, certainly understand the example. I think in that example, the 25,000 would cover that, even though it is greater than the 10 or 20% in that instance. I do just worry, with some of the contracts that we've been signing. We're on some large projects. We just signed one a little over $900,000. 20% would be $180,000, close to $200,000 that you'd be able to change if it's within the budget. So I certainly understand that piece. So I would be concerned with some of these larger projects, right? So, yeah.
Thank you, Mr. Chair. And that's a great call out there. I think about, I know that our current city manager is very responsible and would never, do something outside the ordinary. But if you think about the scale of, for example, the entire downtown project, if there was to be if the design phases aren't the big check, right? But if the big check was millions of dollars, then, and there was a 20% variance allowed on that, it might be worth considering putting a cap on the number to say that up to 25,000 or 20% up to X, and just putting, because it could be something very large depending on the contract.
Yeah, we did talk about that also. So right now I have 10%, no cap.
Yeah.
And so that would actually be a step backwards. But it's very rare that we are going to have the money in a project with that kind of change. When we go out to bid in a project, typically they're more than we have available for funds, and we have to come to you anyways and ask for additional funding. They're not usually big dollar amounts left in a project line.
Clarifying. So it would not authorize to be able to pull from the general fund to fund the project?
No. The council has to authorize additional funds. It only allows me to work within the budget for the project, up to those guidelines.
Thank you.
Okay.
I'm good.
So I think this is very appropriate, partially because the language he's been dealing with is pretty old. And I guess we know what happens when you forget to review your ordinances and things like that. But in reality, this is it's an economy of scale at this point. What was $20,000 when this was written is probably $100,000 today in what our costs are. And when we build a system that hampers the forward movement, it's just kind of foolish, given the time frames we have and the amount of work that needs to be done. I think these are quite appropriate, and it does clean up a lot of ambiguous stuff. To the big question about, what if it's a big project? Well, if it's not funded, can't do it. And to your same point, and that's been said over and over again, not worried about the city manager. Yes, sir.
I just have two minor comments relating to the language, both on the first page, section 2-1332, rules for city purchases. Under 1, I would just ask that we change the last sentence from the city manager may in his discretion to the city manager may in their discretion. And then a Scribner's error in number 2, just a $sign before the 50,000.
Goes to show
Thank
you
you.
that finance people read these things. All right, any further discussion? Good work, thank you very much.
Thank you.
Whose motion is it? Brian?
Move to recommend the adoption of ordinance O 2023-15.
And I second.
Okay, it's been moved and seconded. Any further discussion?
He may resolve my question.
I'll take the first one. Actually, just a quick question for the city attorney on the language that Councilor Madison called out. Do we need to make an amendment to change that, or can that be attributed to Scrivener's error? Thank you.
We're going to have to re-school that Scrivener one of these days. Right?
Thank you, Mr. Chair. My question was actually whether the conversation around the fact that it can't be funded from outside the project helped Councilor Lake like it did for me. That helped clear up my concern around the 20%, but I wanted to follow up if that cleared your concern or not.
I still have some amount of concern, but because we have it in the budget already, that does ease at least some of the concern there. Enough so that I do not intend at the moment to make an amendment.
Thank you.
Okay, so did we get a motion? We didn't- Any further discussion? All in favor? Unanimous. Thanks, Finance. Mr. Engineer?
Thank you, Mr. Chair. Don Lucio, City Engineer, and pleasure to be the last on the agenda tonight. The resolution that I'm here to talk about, Resolution R-2023-37, is related to an issue that we actually talked to you about a year ago. You may recall in October of '22, the city manager came forward with a request to authorize her to negotiate and execute an agreement with the community college system of New Hampshire related to the guardrails along Woodbury Street. And the issue the item at issue at that point was related to the agreement and exchanges of easements with CCSNH. So it went to PLD instead of THITS committee. But that agreement was negotiated and executed, and basically it calls for CCSNH to be responsible for, repair, and maintain into the future the retaining wall that runs along Woodbury Street next to the Roosevelt School, former Roosevelt School. The city, conversely, is responsible for the repair and maintenance of the sidewalk and the guardrail along the top of that wall. And our friends in the AV booth has posted a picture here just to kind of refresh your memories of what's there today. You're standing with your back to Woodbury Street and you're looking out towards Washington Street, sorry, in this photo. So Roosevelt School is on the right, and that's the guardrail that we're talking about. So in the existing conditions, I'm going to do some air quotes. Air quote guardrails are 2x8 boards that are bolted onto railroad ties embedded in the concrete rubble masonry wall. So to say that guardrail doesn't meet modern safety standards would be a bit of an understatement. And to be quite honest, I think we've all been happy to sort of turn a blind eye to it for a number of years because, frankly, it's a difficult situation to repair and address. But the fact that CCSNH is now looking to sell this property and it's going to be redeveloped has sort of brought this to a head. So I think there's no question in my mind anyway that these safety repairs, these safety improvements do need to be done. We've worked with both the community college system and their buyer, who happens to be Keene Housing, to develop a plan for the safety improvements that sort of everyone can live with. The CCSNH has entered a purchase and sale agreement with Keene Housing. That calls for them being, responsible for fixing the wall in the first instance, and then it gets turned over to the new property owner for maintenance into the future. The structural engineer that CCSNH hired to do the design and repair of the wall had some significant concerns about, attaching or mounting the guardrail immediately adjacent to the existing wall. There just are no real records of how that wall was designed or built. So it's very difficult for an engineer to say that, it can absorb an impact from a vehicle hitting it at 30 miles an hour. So instead, the concept that we've come up with will put a pedestrian safety railing, essentially a chain link fence, along the top of the wall, and a guardrail between the sidewalk and the traffic on Woodbury Street. That moves any impact loads from cars hitting the guardrail far enough away from the wall that the mass of earth between them absorbs that energy. So that's the plan. Everybody's on board with that plan. Of course, we do need funding. So the resolution for this, because it wasn't programmed or coming through normal channels, would appropriate funds out of the unallocated fund balance to cover the cost of construction. Over the last year, we've also talked with the project manager for the community college system about how we're going to go about implementing these repairs. Their contractors working on the wall, both the front side and the back side. The top of the wall, our contractor is going to be building the sidewalk upon the wall. So it's really, the two pieces of work were sort of intertwined and not easily extricated. So what we've decided and recommend at this point is that we will incorporate the repairs that the city is responsible for, the sidewalk repairs, the fencing and the guardrail, into CCSNH contract documents. They are going to be putting that contract out to public bid. They will administer the contract. Our staff would be involved in inspecting and accepting the work that will eventually become public infrastructure, the guardrail and the sidewalks and the fencing. So we wouldn't be completely absolved of our responsibilities. We would still have a hand in overseeing it. But it would allow that work to be done as one piece of construction and I think a lot more coordinated way. So the second piece of the resolution that's in front of you tonight would authorize the city manager to enter into a reimbursement agreement of some sort. Likely that's going to be like an escrow account that we'll set up to reimburse them from that. But a reimbursement agreement of some sort with the community college system and also to expend the funds raised by the appropriation for the purpose of building these improvements. I will say that the amount that's requested, I anticipate is more than we're going to need. But right now, we don't have a good price estimate to give you. The estimate that me and my staff came up with was actually $165,000. But this is going to be bid in the spring. I'm not real confident about that number or what's going to happen in the interim. So we did ask for a little bit of a cushion there to give us a little more budget to play with. And I would be happy to answer your questions.
Thank you. Questions up here? Start on that end.
So the wall itself, like even though you're saying you're going to be moving the fence and railing over, I mean, there's a tremendous amount of damage and cracks in that wall.
Correct.
And are you saying that they're responsible for that wall and we're not?
That's right.
So we could make this great improvement above, and if they don't do their part, it's not going to matter how, I mean, it's a vulnerability in terms of like how well what we create withstands any impact, would be my concern.
So the agreement that the city manager negotiated with the community college system does stipulate that they are responsible for the repair of the wall in its current condition and also the ongoing maintenance into the future. So they would have responsibility for maintaining the structural integrity of that wall.
But I guess what I'm asking is, is it within that contract, does it specify that those repairs need to be made prior to the city investing and installing?
So
fen-
they will they will be done at the same time. And so the plan is to combine the work that they're doing to repair the wall with the work that we are doing under one contract.
So 12 years ago, when I ran, I brought this issue up to the city, and a lot of discussion. I brought it up even another year later with Court Bloomquist, and actually in public record, in public meeting. I was a ward counselor, and this was something that people in that section of town were upset with. So 12 years later, but thank you.
Mr. Chairman, I'd
That's
also.
government, but Keene Housing's not gonna buy it if that wall's not fixed. I mean, that's the real,
Yeah, my understanding is that the purchase and sale agreement is conditioned on this wall getting repaired and this issue getting resolved.
And Mr. Chairman, I would like to point out that the new owner of this wall has a huge incentive to make sure that their engineers and their contractors do it right going forward, because the liability would be quite large if they don't.
I have a very hard time with the cost on this because it's 300 feet and it's like $700 a foot.
Well, it's a little more than 300 feet. I think it's about 340 altogether. But that cost includes the cost of the guardrail, the sidewalk, and the fencing.
I guess if you go all the way to the corner, it could be 340. I was going to like where the fence starts today.
Yeah, it'll go a little bit further than it goes today, and it goes right to the property corner on the backside.
Okay. Yeah, I just still, I mean, even with the 165, I'm trying to understand. Again, I'm not against pushing it to the council meeting, but I would love to understand the buildup of that 165, even if you think there's extra.
Sure.
Because that's a lot of money for fence.
Sure. Well, we can certainly make the estimate available.
Yeah, yeah. Thank you.
how wide is that sidewalk?
The sidewalk standard is 5 feet. We've scheduled it so it'll actually be 5 feet 6 inches clear between the fence and the backside of the guardrail. The guardrail we're going to be installing will have a rail on both faces, unlike typical highway rail. Because we're going to have bicyclists and whatnot walking there, we didn't want sharp edges that people could get caught on. But it will have 5 feet 6 inches clear.
Thanks. Anybody else? Motion, please.
Move to recommend the adoption of Resolution R-2023-37.
Second.
It's been moved and seconded. Any further discussion? Members of the committee? Seeing none, all in favor? No one's opposed, it's unanimous.
Thank you, Mr. Chair.
you. We're gonna use the mayor's.
He was here, so.
Adjourned.